Hi, everyone. I think we're going to go ahead and get started. Welcome to the webinar, Estate Planning for Blended Families. Now, if you can't see my screen, just drop something in the chat and we'll try to work that out, okay? I am Stephanie Himel-Nelson, and I'm so glad you've all been able to join us today, and hopefully you're going to learn something new today. So for the next hour, 45 minutes, I'm going to share with you all of the secrets of estate planning. There are a lot of misconceptions out there. So my goal with this webinar is to leave you with a better understanding of what can go wrong if you don't have any estate planning in place, and what are the essential documents you need, how to get them in place, so you can make educated, informed decisions about what's best for your family. And the best way to get the most out of your time on the webinar today is to turn off your phone, close your door, close out of Instagram or Facebook or whatever you're doing. You'll get a lot more out of this if you get rid of all of those distractions. And be sure to stick with me until the end of the webinar because we're going to have a bonus, and that's at the very end. Now, you should have gotten an email from us with the webinar workbook. And if you didn't, it's included as a handout in this event. Maria is going to upload it to the chat right now. So you can go ahead and print it out or just open it and refer to it throughout the webinar to stay engaged and make sure you get the most out of the event. So think about your questions while we're going through this. Write them down in the workbook so you'll have them ready to ask at the end, or you can drop them in the chat. And then finally, I want you to think about the people in your life you care about the most. They're the reason we're here. So we don't do estate planning for ourselves, we do it for our loved ones. So I realized that estate planning is something that's not all that fun to talk about or think about unless you're a geek like me. In fact, almost 70% of Americans don't have an estate plan in place. No will, no trust, nothing. And many of you on this webinar today are probably part of that 70% with no documents in place, and that is fine. This is a no judgment zone. That's why you're here, to learn. Okay, so we're at question number 1 in your workbook. What are the 3 biggest doubts that people have about estate planning? So first of all, there's this sort of fear that planning for death is somehow going to make it happen. And we all know that this is completely irrational, but it's true. You know, if you just keep putting it off, you don't have to think about it. You can avoid those uncomfortable thoughts, and maybe it's just not going to happen. This is really common. So, you know, don't worry about it. But another thing that I hear is it's going to take too long and I don't have enough time. And I get that because this is a process. But we're going to talk later on in the webinar so you know exactly how long that process is and what's involved and even how much it costs. And I think that makes it a little less scary and you can plan for it. And then finally, many people say to me, you know, why do I need to do this when I'm only in my 30s and 40s? Is it really necessary if I don't have millions of dollars in the bank? And we're going to talk about that. So if any of this sounds like you, just know that this is normal and you are in totally good company. So the good news is that I have never had a client sign their will and then drop dead right afterwards. I'm going to knock on wood. But yes, getting an estate plan in place does require an investment of money and time. But I think you'll find that the benefits of estate planning far outweigh those costs, both financially and emotionally. And then finally, you'll see as we go through this webinar that the benefits of estate planning really have nothing to do with how old you are or how much money you have in the bank. And at the end of the day, when we talk about estate planning, the big picture is that it's not about you, it's about the people you love the most, the people you would leave behind. So my definition of estate planning is that it's about making sure that things are as easy and as inexpensive as possible for your loved ones when you're gone. And you care about that no matter your age and whether you have $10 or $10 million. So this is question number 2 in your workbook. Who are the people that you care about the most? Who are you doing this estate planning for? And go ahead and write that down. So this is our agenda for today. You're going to get some of the same information you would get in a one-on-one personal consultation with me. We're going to talk about your estate planning options, the difference between a will and a trust, And by the end of this webinar, I want you to have an idea of what's the best choice for your family. I'm going to talk a lot about probate court and how you can avoid it. And if you have no idea what probate court is, do not worry. We're going to talk about that later in the webinar. And we'll also talk about how to protect your children, including naming guardians for minor children. So we'll discuss how to craft fair and equitable inheritance plans, as well as how to protect an inheritance for children in blended families. I'm going to talk for about 45 minutes, and then we should have some time for questions. We're also going to go over how to start the estate planning process, what's involved, and how much it will cost. By the end of the webinar, I want you to have all the information you need to make a decision about your own estate plan. A little bit about me. Again, I am Stephanie, and I'm an estate planning attorney with Jennifer Porter Law. We are a military spouse-owned firm based in Northern Virginia and Hampton Roads. I've been a practicing Virginia attorney for 23 years, and I'm also a former military spouse. My husband is retired. So here is all of my contact information. You can take a screenshot of this, get a photo, or use the QR code for my information. And please feel free to call or email if you have any questions at all. So just like many of you, my reason for being here, for doing this, is my family. I live in Chesapeake, Virginia with my husband, who is retired from the Navy, and our 3 boys. Our oldest is off at college at Virginia Tech, our middle is at William and Mary, and our youngest is 10, going on 20. My husband and I both have aging parents, and we've got college expenses, lots of college expenses, and saving for retirement. And of course, we also want to make sure that our youngest is cared for if something happens to us. So I get it. I know how overwhelming it is and how hard it can be to know just where to start. So today I'm going to show you how to start planning. I mentioned earlier that most people don't have an estate plan, but that's not entirely true. Most people think they don't have an estate plan because they haven't formally done a will or a trust. But the truth is you do have an estate plan even without those documents. It's just that the Commonwealth of Virginia has written it for you. So these are some of the things that estate planning accomplishes. And I'll go through each of these quickly because we're going to address most of them during the webinar. But think about which of these are most important to you. You know, avoiding probate court, maximizing assets that are going to your loved ones, caring for yourself during incapacity, giving what you have to the people that you want the way you want to, protecting others and their inheritance. You may want to pass on certain values and ideals to your children or your grandchildren. You may have charitable intentions that you want to fulfill. And of course, taxes, death and taxes. You may want to minimize taxes at your death. So if you die with no estate plan, without a will or a trust, it's called dying intestate. And this may be the situation that many of you are in now. This is the doing nothing approach. And it means you'll end up with Virginia's default plan. So let's talk about what that actually is. Oops, I'll go back for a sec. So what happens if you die intestate is your assets are going to be distributed according to state law. So they could go to people that you don't want. Your kids are going to get their inheritance outright as soon as they're old enough, and there are no guardrails in place. A judge is going to decide who will be in charge of your children's money and who raises your children. Your spouse could remarry after death, leaving money to a new spouse and kids. Or if you're part of a blended family, could decide to disinherit your children later on. But either way, if you don't have a will or a trust in place, you are absolutely guaranteed to be going through probate. So this is for the parents who are on the webinar. If you have minor children, kids under the age of 18, one of your top priorities should be getting in writing who you want raising your children if something happens to you and your spouse or partner. In fact, I think for parents of minor children, estate planning is more important than for almost anyone, even the elderly, because there is nothing more important than making sure your kids are taken care of by the people you want the way you want, no matter what. And if you're part of a blended family, this is even more crucial. It's important to make your wishes known to any co-parent, particularly if you have half siblings that you want to stay together or you want to keep in contact. So the rule is if you haven't nominated guardians in a will and you and your partner or spouse pass away, a judge is going to decide for you. In other words, a complete stranger is going to decide who gets permanent custody of your children. And because you didn't get your wishes down in writing, they have no choice to figure out who you would have wanted on their own. And every judge is, of course, going to do the absolute best they can with the information they have, but they don't know your family, they don't know your preferences, and they don't know what you would have wanted. This is question number 3 in your workbook. If you don't nominate legal guardians for your children, who will name them for you? So they could end up naming someone who looks really good on paper, but you know in real life is the last person you would want raising your children. And this is something that happens in a permanent guardianship proceeding. So in a permanent guardianship proceeding, a family member or a friend would have to petition the court for custody of your children, and a judge makes the final decision. And this kind of proceeding is rigorous, it is complicated, it is emotional, it takes a long time, and it is expensive. So you want to avoid this if at all possible. And the way you do that is by setting up a will. This is the legal document where parents nominate guardians. So another reason you want to get your wishes in writing in a will is because what if more than one family member wants custody of your kids? What if your sister wants custody, but so do your husband's parents? And this is something I hear a lot. I have a client come to my office and say, well, there are a lot of people in the family who would want my kids, so we're absolutely fine. And this is actually more of a problem because if you have not said which of those family members you prefer and in what order, your family might end up in court duking it out, and your kids are going to get stuck in the middle of that, and you don't want that. So the solution is to nominate guardians in a will. If it's a couple, you can say what happens if they divorce or one dies. You can nominate backups in case your first choice isn't available. Okay, so let's talk about your actual estate. Who gets your money when you pass away? And if you want to leave everything to your cat, that is absolutely an option. But let's talk about your other options. First of all, when I say estate, what does that mean? Though many of us think we don't have an estate, that's only something that really wealthy people have. You think of big houses. But we all have some of these assets or accounts. You've got a checking account, you've probably got a house, you may have a retirement account, life insurance proceeds, you may own a small business, you might have artwork, you might have intellectual property, copyrights, or patents. Now, before we get into your 2 options, a will versus a trust, I want to talk a little bit about why title is so important in estate planning. So the magic rule is this: where the asset goes when you pass away depends on how it's titled. So there are 3 ways that you can own property at death, and this is question number 4 in your workbook. You can own property individually, jointly, and with a beneficiary designation. So a bank account that you own, just you, not jointly with anyone else, is owned individually. A bank account with 2 or more owners, like a husband and wife, is owned jointly. And an asset like life insurance or 401k has a set of instructions, a beneficiary designation, as to where it goes when you're gone. So this is the key. You still need to do estate planning, even if everything you have is held jointly with your spouse, or it all has a beneficiary designation. And if you're part of a blended family, chances are you and your partner both have assets that you own individually, or you may have assets that you want to go to children from an earlier marriage, your current marriage, or stepchildren that you want to include. Now, you may be thinking, I don't need to do estate planning because everything I own is either joint with my current spouse. So if I die, everything's just going to go to them. And I trust my spouse to take care of my kids from my first marriage. And while it's true that jointly held assets do just go to the other owner when you pass away, we also have to account for what happens when the second owner dies, or God forbid you die at the same time. Jointly owned assets avoid probate when the first of you passes away, but they don't avoid probate at the second death. And we're going to talk a little bit more about probate in just a bit. But if you die first, You don't have any control over what happens to those assets. I mean, what if your spouse remarries? What if they get angry at one of your kids and decide to leave your inheritance to someone else? It could happen. Okay, beneficiary designations. Some assets like life insurance or a retirement plan have sort of a built-in mini estate plan. It will just get paid to whomever you've named as a beneficiary when you pass away. So generally those assets don't have to go through probate court either. But that is assuming that the beneficiary is over the age of 18 and actually alive when you pass away. If either of those things are not true, those assets will have to be probated. So just as important is that the proceeds are going to be paid outright. So let's say you've named your 20-year-old son as a beneficiary on your $500,000 life insurance policy. Do you really want a 20-year-old getting a check for 500K? I don't know about that. With no rules on how and when he can spend that money. I mean, I have a 20-year-old, so that kind of strikes fear in my heart, but even the most mature of young adults just doesn't have the life experience yet to really understand or manage that kind of an inheritance. So a better idea is to set up a trust, name the trust as the beneficiary instead of your son, and then put some rules in place as to what he can spend the money on and how and when. Okay, so we've sort of talked about why it's important to do estate planning no matter what assets you have. What are your options? And I've mentioned them both so far. But as we go through those two options, I want you to be thinking about which one makes more sense for you and your family. So you have two options, a will-based estate plan or a trust-based estate plan. This is a decision everyone is going to make, whether they're married or single, kids or no kids, regardless of how much money you have. You have to decide if you want a will or a trust. And as I mentioned earlier, the vast majority of my clients and people today do a trust instead of a will. But I do want you to understand both options. This is question number 5 in your workbook. So write it down. So let's look at a will and what it accomplishes. This is definitely better than nothing. And if you have a will in place, you get a gold star for adulting. Go you. This is also the document where you name guardians for your minor kids, and you can name beneficiaries for any asset or account held in your name alone, and you can name an executor. In Virginia, we call this the personal representative. And this is the person who's in charge of wrapping up your affairs in your estate when you're gone. So those are the things a will does. And unfortunately, it's about all a will does. You can see that it doesn't accomplish really all that much, and it comes with some downsides that many people aren't aware of. First, as I mentioned before, wills have to go through probate court at death. And we're going to talk about why probate can be bad in just a few minutes. Also, your will is only effective at your death. So it doesn't help at all if you're disabled and unable to manage your own affairs. So what happens if you're in an accident and you can't communicate your wishes about healthcare, you can't physically pay your bills or communicate what you want? A will is not going to help you in those situations. And this is pretty common. I mean, many of us will become incapacitated at some point before death. So each state has their own laws regarding wills. So a Virginia will may not be effective in California or Florida. So if you do a Virginia will and then you move, you may have to redo your estate plan. Some things may be legal here in Virginia that aren't elsewhere. You may not be able to disinherit someone in some states. There are just rules about how things have to be witnessed and attested to, and it's different in every single state. So that can be a limitation of a will. And then finally, most parents do not want their kids to just inherit everything when they turn 18, which is the age you're legally entitled to inherit money. Most parents want their kids to get it a little later in life when they're more mature. And, you might want to say, you can have this when you finish college or trade school and you're 25. But you can't say that in a will. You can only do that in a trust. And I also mentioned that many assets are outside of the reach of a will and don't go planned for. So they don't control property that's jointly owned with someone. They don't control retirement plans, annuities, insurance policies, or anything that has a direct beneficiary. And finally, a will just transfers property at death. You can say, I want my money to go to my daughter when I pass away, but you can't say when she's 25 and has finished college. You aren't allowed to do those sorts of instructions in a will. You would need a trust for that. Well, here it is. We're now to probate. And if you have a will, you must go through probate. And while your court experience probably won't be as traumatizing as Colonel Jessup's court experience here, it won't be all that pleasant either, because court is just, it's never a very fun process. So what is probate court anyway? So basically, the main purpose of probate is to change the title on the property you own when you die from you to your family. So your personal representative, your executor, is going to do a full inventory of your assets and an appraisal of each asset as well. If anyone's contesting the will, those disputes get settled in probate court, and then the assets are distributed to your beneficiaries. But a judge oversees this whole process, and you need court permission to do anything. You need court permission to wrap this up. And typically your family will have to hire a lawyer because it's a complex process. So there are three big downsides to probate. It's expensive, it can take a long time, and it's a public process. And this is question number 6 in your workbook. So probate can be expensive. There are various fees associated with probating a will, court fees, legal fees, executor fees, and they can eat up as much as 1 to 5% of the estate assets. And these fees are going to reduce the amount of money that ultimately goes to your family. So let's look at an example here. Rebecca is a single woman. She's created a will and left everything to her daughter, Megan. Megan is currently 10 years old. Rebecca has a house she lives in worth $400,000, and also a house she rents out that is worth $100,000. She's got an investment account with $250,000. She has life insurance payable to a minor and a retirement account paid to a minor. And because minors cannot inherit property directly, those assets now have to go through probate court. So a judge can make sure the money is being handled properly. So these assets become part of the probate estate. So when we add up all these assets, they total 1.8 million. Excuse me. And remember how before I told you that probate can cost as much as 1 to 5% of the probate estate? When Rebecca dies, her will leaving everything to Megan is going to need to go through probate court. Her family is going to have to hire a lawyer to probate the will. And let's say it only ends up costing 2% of the total estate. That's still $36,000 lost in probate. That's $36,000 that's not going to Megan. It's going to lawyers, court, and probate fees. Now, this can be a significant amount. Probate can cost a significant amount, even for middle-class families. The second downside to probate is that it can take a long time. Even the simplest of estates can take months or years to probate, and the minimum in Virginia is 6 months. So your assets are frozen for the duration, which is a problem if you're counting on that money being available for the care of your minor children. And it's also an emotional burden for your family because it's dragging this process of settling your affairs out over several years, because the court's got to oversee that money until a minor reaches 18. Probate is also a public process, and I think that most of us would agree that there are not many things that are more private than our relationships with our family and our financial situations. But if you die with a will, your estate will be a matter of public record. Once you probate that will, anyone can go down to the courthouse and look it up and see what assets you left behind, how much they're worth, and who you're leaving them to. You end up sharing very personal information with anyone who cares to look. And there are definitely people who look every day, every week, your local courthouse, absolutely. This can make your minor children vulnerable to all sorts of unsavory individuals because their names are going to be in your will right alongside how much money they're going to be inheriting when they turn 18. And so this is the third downside to probate court. And just think about it, which of those three bothers you the most? I mean, I don't think you have to pick one, but everyone has something different. So you may be asking yourself, knowing all of these downsides, why would anyone do a will? And I get asked this all the time once people see the downsides of having a will. And the answer is that if you have less than $50,000 when you pass away, you're eligible for a simplified probate process that's very easy and inexpensive. So in that case, a will might be sufficient. But if you have more than 50,000 and you want to avoid any of the downsides of probate that we just talked about, a will may not be the best choice. So you may be thinking, why, if a will is not going to accomplish my objectives, what do I want to do? So let's look at your second option, and that is to do something called a revocable living trust. And this is probably the option that, 75% of my clients choose, and almost 100% with minor children. So what is a revocable living trust? I like to call it a will on steroids. It's a legal document that you'll create. It's very similar to a will. It's witnessed and notarized when you sign it, just like a will is. You're going to list the people you want to inherit your money when you're gone. And just like a will, the trust is revocable. That means you can change it or even revoke it entirely at any time. And your revocable living trust is going to have a trustee. That's you. You're in charge of both the trust document itself and the assets that go into the trust. So the way it works is you create and sign the trust document, and you're going to give your trust a name, maybe the Jones Family Trust. And everything you own is now outside the trust. You want to move your assets into the trust by retitling them while you're still alive. So keep in mind that you still have total control over any assets in the trust. You can still use them, spend them, sell them, move them in and out. Nothing changes. But the benefit is that everything inside the trust goes to your beneficiaries without going through probate. So this is huge, right? Now, I bet you're thinking also, aren't trusts only for rich people? And if you're thinking that, you would be wrong because trusts are for everyone. So simply put, a trust is an agreement that spells out the rules you want followed for the assets owned by the trust when you pass away. That's it. And put another way, a trust solves many of the problems people assume are solved by a will. So let's look at an example because I love examples. This is Bob, and he has $100,000 in a bank account. He wants this to go to his daughter, Ava, when he dies. But he also wants Ava to be 25 and have finished college before she gets the money. Education is very important to Bob. Bob needs a trust to do this. He is not wealthy. He's not setting up a fancy trust because he's leaving millions behind. He's just putting some rules in place. He wants his daughter to be 25 before he inherits, and he wants him to finish college. So Bob needs a trust for this, even though he doesn't have a very complicated estate, because he wants to control how and when his daughter gets his inheritance. And that's it. There are three roles in every trust. You've got a grantor, or sometimes called a settler in Virginia, because we like to come up with our own terms. But your grantor is the person who contributes assets to the trust. The trustee is the person who manages the trust assets, and the beneficiary is the person who is entitled to the assets. And with a revocable living trust, you hold all three of those positions while you're alive. You're the grantor, the trustee, and the beneficiary. Another example. So we have Harry and Wendy, Harry for husband and Wendy for wife. They set up a revocable living trust and they occupy all three positions. They have total control. They're the grantors, created the trust, and transferred title to their assets into the trust. They occupy the manager's role as trustees. They make all the decisions about their assets. And finally, they're also the beneficiaries of the trust, and they have the right to spend and use the assets in any way they want. In other words, Harry and Wendy still have complete control over their assets, even though they're titled in the name of their trust. And what does it mean to be in total control? It's just business as usual for Harry and Wendy. They can amend their trust or even revoke it if they want to. They have all the rights to manage the property And their income tax forms are even filed in exactly the same way they've always done it, with their own Social Security numbers. And their property taxes on their home are paid in the same way as well. Because this is a revocable trust, the government ignores the trust for tax purposes and continues to tax Harry and Wendy as individuals. Now, the magic is in how you hold title to your assets. And I keep talking about the importance of title. Well, here you go. This all comes into play when we're talking about revocable living trusts. So question number 7 in your workbook, think about your revocable living trust as a kid's backpack. So when your kids start school, they can pick out a backpack and it can be any color, any size. There are a million different options and they probably have very strong feelings about it. Your trust is the same way. You set it up so that it accomplishes what you want it to accomplish. And the goal is to have your trust hold all of your assets, because then those assets will be distributed according to the terms of your trust without going through probate when you pass away. So your trust document is like the backpack. You set it up exactly how you want it, and then you move all your assets into the trust. And then when you pass away, everything held by the trust goes to your family. So right now, all of your assets are in your name, which is bad. And you want all your assets to be in the name of your trust. You want it in the backpack. Again, funding your trust is simply changing the ownership or retitling your assets, so the trust owns them instead of you. Just like this lady is putting all her stuff into her backpack, you will put all of your stuff into your trust. So a trust solves a lot of the problems that come with a will. You're not going to lose 1 to 5% of your estate in probate court. Your assets can go to your family in weeks instead of years, and it is totally private during life and at death. Some other benefits of a revocable living trust: it's easy to amend. As your life changes, you can make changes to the trust document. The trust does not get a separate tax identity, so your income taxes don't change at all. You're still going to pay them the same way. Your trust can cover all of your property, including beneficiary assets and jointly held assets. And it's really not any more difficult to create and maintain than it is a will. But bonus, a trust is valid in all 50 states. So you're not going to have to redo your estate plan every time you move. And because it's a private document, nobody knows what's in it. So it's harder to contest and it's less likely to face fraud and fraudulent claims. So you may be wondering, if you have kids, if I do the revocable living trust and not a will, where am I going to nominate guardians? Didn't you just tell me that you needed a will to nominate guardians? And the answer is, when I create a revocable living trust, I also create a very basic will that goes with it. It's called a pour-over will. And what it does is it pours over any asset not in your trust at your death into your trust. So it's kind of like a safety net. And you'll also use the pour-over will to nominate guardians. So stepping away from the will versus trust question, by now you may have decided in your mind which you think you want, and we're going to talk about how much each one costs in a few minutes. But the second big issue I want to talk about is, how are you going to design your backpack? What do you want it to accomplish? And one of the biggest things parents worry about in blended families is that their spouse will later decide not to leave any of their assets to children from a first marriage. And the second biggest thing parents worry about is that their kids are going to lose their inheritance in some way to divorce or creditors or lawsuits or something. And these are very real possibilities if you give your kids a big lump sum on their 18th birthday. But we can design your backpack or your trust to account for both of these concerns. Another example, Harry and Wendy have 2 grown kids, Denise and Sam. Denise is Wendy's child from an earlier marriage, and Sam is Harry's child from an earlier marriage. And Harry and Wendy have taken no steps to make sure the wealth is not wasted once they're gone. They just have simple wills, which sort of just dump a huge windfall on both Denise and Sam if something happens to both of them. They're leaving behind $2 million total. In this case, Denise and Sam will each receive $1 million from their parent, which represents a lifetime of their hard-earned wealth. Denise is married to Jason. Jason isn't a very hard worker, and he doesn't do much to support the family. Denise gets her $1 million inheritance and puts the entire thing into joint bank accounts and investment accounts with Jason. She has now commingled that money, and when they get divorced 5 years later, Jason's entitled to half. And this is probably not what Harry and Wendy would have wanted. So, Sam, on the other hand, Harry's son, he takes his $1 million and he dumps it into his checking account. Maybe he's got a good rate. I don't know. Sam isn't married, but he is accident prone. He leaves the water running in his bathtub and then he goes out for the night and floods the apartment below his and the one below that. His downstairs neighbor sues, and Sam loses his entire inheritance, settling the lawsuit. So this is also the last thing that Harry and Wendy wanted, to work hard all their lives only to see Sam lose everything in a lawsuit and their daughter lose everything in a divorce. So the solution for this is something called a children's trust. And think of children's trust like a tube of toothpaste. This can help ensure that Denise and Sam's inheritance isn't lost. So we're on question number 8 in the workbook. The mistake Harry and Wendy made is that they gave their kids outright distributions. Giving outright distributions to your heirs is just like squeezing all the toothpaste out of the tube right onto the counter. Once it's out, it's impossible to get back in. The money is just there, and it could be commingled with a spouse, lost to a creditor, lost to a lawsuit, or spent unwisely. There's no way to get it back into that tube. And honestly, this is how it happens most of the time. This is how most estate plans in America are drafted. Divide it up, dump it out, and just, watch it get dissipated. But we can do something different. Instead of squeezing all the assets out of a trust and giving them outright to the kids, what if we divided the shares but kept them inside the trust where they could be protected? This is how a children's trust works. Each child gets their own tube of toothpaste with their inheritance in it, and they can squeeze out money whenever they need it, but whatever hasn't been spent can't be lost to divorce, creditors, or a lawsuit. And we can use a children's trust for grandchildren as well. So if you have adult children who are all very responsible, you can account for what happens if, God forbid, one of them predeceases you and you end up with the grandchildren inheriting. So when you do this, you pick a trustee for the trust, and your adult child can even be their own trustee and at a certain age, if that's what you want. And it gives your children and your grandchildren access to their inheritance while still protecting it. So if you'd like to put these kinds of protections in place, you set up a children's trust along with your revocable living trust. And many of my clients choose this option. They'll do a revocable living trust to avoid probate, and also a children's trust to protect their kids' inheritance or to control and make sure they're a little bit older when they access it. So next, let's talk about how you protect the kids from first marriages or second or third in a blended family. So in the case of Harry and Wendy, they agreed to split their assets 50-50 between their kids if they both passed away. But what happens if either Harry or Wendy dies first and then later decides to change their will? What if Wendy dies first and Wendy's daughter Denise gets into a huge argument with Harry at Thanksgiving dinner? Maybe it was over politics. Maybe it was football. Who knows? Well, Harry can decide to go change his will or his revocable living trust and leave all of his assets, including what he inherited from Wendy, to his biological child alone. He can leave it all to Sam. And we can avoid this by splitting assets into separate, irrevocable trusts when one of you passes away. And I often use this planning method even for families where children are all joint, because it can be a real concern that if a spouse remarries and has more kids, or has a spouse with children, that later on, all of those kids may not be treated equitably. And it's hardly ever intentional. Sometimes it's a big blow up, but sometimes it's unintentional disinheritance, not understanding what will happen to your assets upon death with remarriage. Now, this can be a really hard discussion to have for blended families, but even, original, traditional, two-parent, all our kids are joint families. This is a really hard discussion to have, but this is an important one to ensure that all the children from your family, blended or not, are treated fairly when a parent dies. It can also help family harmony if who gets what is already settled and understood long before anyone passes away. So how can we avoid conflict and feelings of unfairness when doing estate planning with blended families? This is question number 9 in your workbook. Now, the first thing is clear and open communications with all of the family members involved. This can avoid potential resentment, conflict, and even litigation. If it's not a surprise, you can discuss it ahead of time, let everybody get their feelings out ahead of time, then not everything blows up when someone passes away. Second, you can use trusts to establish boundaries and protections, and that can ensure your spouse and your kids get their inheritance without jeopardizing your spouse's interests as well. I often use qualified terminable interest property or Q-tip trusts, and they have a really cute name, but they can also provide for a surviving spouse while guaranteeing that any remaining assets pass to your children after your spouse dies. Finally, using a neutral third party as the trustee of your trust once you pass away can ensure that no one feels they're being treated unfairly. It's easier to get, it's easier to get mad at the stepmom or the aunt, but it's a lot harder to get angry at a neutral trustee with fiduciary duties. Again, these are not easy discussions to have, but in the long run, they help avoid even more explosive conflict when you or your spouse passes away. So I want to talk really quickly about estate taxes because I will definitely get this question. I always do. And estate tax is a tax that is due when someone passes away if they have more than a certain amount of money. There is a federal estate tax, but in Virginia, we do not have an estate tax. We're lucky there. But if you are married and die with more than $27.22 million, your estate is going to have to pay federal estate taxes. And if you have that much money, I would like you to adopt me, please. Thank you. Anyway, I have an asterisk here on the screen because it's 13.61 million per person, but that amount may revert back to 5 million per person if Congress doesn't renew legislation by the end of 2025. So right now I'm just assuming that Congress is not going to act and it's going to drop down to 5 million per person adjusted for inflation. And if you're in this category, you can reduce the tax liability that you have by doing more advanced planning, but that's kind of beyond the scope of this webinar. But if you'd like to talk about it more, then, just give me a call or shoot me an email. So the information portion, trust versus will, is over. And now we're going to get an action plan in place and ask these basic questions. What do you need to do? How do you make it happen? When should you get started? And what's the investment to get this done? So I also always get this question, why can't I just make my own will or trust online? It's so much less expensive. Well, DIY is great for crafts, but I would not recommend tearing out your walls and trying to fix your own electricity unless you are an electrician. And it's the same for estate planning. Estate planning should be done by an estate planning attorney committed to providing a comprehensive estate plan. There are definitely less qualified options available today for many families that may not know better. In the legal community, we often call these bare bones trusts. They're often produced by attorneys that don't focus on estate planning. Maybe they're just a family attorney or they're a generalist, and sometimes even non-attorneys. We've seen financial advisors trying to do this, or people try to draft them themselves with online software. But beware of these documents because, first of all, they may not comply with state law. Most of the ones I see do not. They don't have important personalized planning to protect you and your family, especially if you have a blended family or if you're concerned about protecting assets for your children after death. These trusts are typically not funded, which means the trust was set up, but the assets were never moved into the trust. And if you don't put the assets in the trust, the estate is still going to end up going through probate. Or I have seen trusts that were funded, but it's been done incorrectly or without the advice of an attorney, which can have devastating tax consequences for your beneficiaries down the line. Absolutely. There are things you absolutely need legal advice on before you just start funding a trust or naming a trust as a beneficiary. You just don't know what you don't know. And there are so many issues here that there is no way I could address them all in a webinar. I could not tell you all of the issues that could arise in a week of webinars. So I don't recommend doing a bare bones trust or trying to prepare those documents yourself. Like I said, you just don't know what you don't know. And here's what I want you to remember. When you work with an attorney, you are paying for guidance and counseling about how the documents should be drafted, not the documents themselves. So let me tell you a little bit about our firm. So we've flipped the traditional experience on its head. We do not bill by the hour. Everything I do is flat fee, agreed to in advance. You don't have to worry about being charged for every little call or question or email because we don't keep track of our time that way. And you may have a million questions, and I have clients who do. I have clients who ask me things almost every day. I promise you it happens, and it's all part of your flat fee. Also, I love creating estate plans for our clients because it's very proactive. We're not responding to negative situations. It's all about making sure your family won't have to deal with an expensive mess when you're gone. And we really do value relationships with our clients. We want to stay in touch with you over time because we know that your estate planning is not something that you just do once and then never think about again. Your life is going to change and the law will change. And we want your plan to keep up with that. So this right here is our virtual estate planning process. First, you attend a peace of mind planning session, which is a one-on-one consultation with me, and that lasts about an hour. This consultation is $400, but I apply this $400 towards any estate planning work we do for you. Before the session, I'll ask you to fill out an online questionnaire at least 3 days before the meeting. And this is going to ask you questions about your family and your assets so I can start to gather the information I need to draft your documents. And in your planning session, I'll hear more about your concerns, your goals. We're going to look at your personal and financial situation, and I'll explain your options thoroughly. And then you can make the best choice for your family. And after you decided to hire us for estate planning, we have a design meeting and we sit down and we actually design your estate plan. I go away and I draft your estate planning documents. I send them to you for review. And then we meet again and we go over your documents. You can ask questions. I explain everything in plain English. And if we have any changes we need to make, we can do that. Then after we finalize your documents, you pick a date to sign everything, and we typically do that in person. Everything else can be done virtually, but signings are best in person. So we do that at one of our offices in Fairfax or in Norfolk, depending on where you are. And then you have an estate plan. Congratulations. And then after that, we'll invite you to keep in touch with us, and we'll send you information from time to time on estate planning and changes in the law, especially if the estate tax changes. And we'll ask you to check in when you have major changes in your life. So if you get married, divorced, have a big increase in income, or start a business, it might be time to adjust your estate plan. Either way, you should reassess your plan at least every 5 years. And if you have changes to make, we can do that for you and quote you a fee, a flat fee at that time based on your needs. Okay, let's talk about our fees. Bargains are good when you're shopping for toilet paper, paper towels, but I would not go cheap on a parachute, a surgeon, or a fire extinguisher. That could have devastating consequences. So estate planning is like anything else. You get what you pay for. And I've already talked about this, so I'm not gonna keep hammering on that, but it is worth it to make the investment to do it right. You know, not doing any planning can cost you more than working with us. So let's say you have $500,000 in assets, house that's paid off $500,000, not much else, and you have minor children. Doing an estate plan could save your family $12,000 to $25,000 and a huge nightmare, even with those limited assets. And it could save your children from losing their entire inheritance later on. So the good news is that our estate planning packages are substantially less than $25,000. This process should save you time and money. That's the whole point. It's about making it easier for everyone later on and saving you money. So we offer three basic levels of protection. We have our basic plan, the peace of mind plan, and the platinum plan. And most of our clients fall into one of these three categories unless they need a specialized type of trust. So you can decide which level of protection meets your family's needs. The basic plan is for people who want a last will and testament. And this makes sense if you have less than $50,000 in total assets, or you just don't really care about probate avoidance. One time I had a client who left almost everything to charity. They didn't care about avoiding probate. It was fine. But that is unusual. So the fee for a basic plan is $3,500 for a married couple, and this includes planning for both spouses. The second level, the peace of mind plan, includes additional protection because it includes a revocable living trust and a children's trust, which is going to protect the inheritance of your minor children or your adult children. The fee for the peace of mind plan is $5,000 for a married couple, and this includes planning for both spouses. And then finally, to add protection from estate taxes, we created our platinum plan. And this provides the broadest protection and requires substantially more planning. So this is for families who have more than $5 to $6 million in assets and need to plan for possible estate taxes. So if you need asset protection planning, that price can vary depending on your needs and what we need to do, but we make sure you know and understand the costs before you get started. But what's really important to know is that all of our plans are based on a flat fee. So before any work begins, you're going to know exactly what it will cost. And if you're single and doing planning for just one person as opposed to two, you can take $500 off that fee. So let's talk about what comes with the peace of mind plan. And this is the option that most families choose. So I'm just going to go through this one real quickly. This comes with everything that you see here. And for both spouses, if you're married, you get a revocable living trust for probate avoidance, pour over will, which pours over into your trust upon death and allows you to name guardians. Let's see. You also get that tube of toothpaste, the children's trust, if you feel you need it. This is to keep your kids' inheritance in the family. We can also include a Q-tip if you're concerned about ensuring assets eventually go to children from an earlier marriage, or you're concerned about your spouse remarrying. And remember how I said earlier that estate planning isn't just about planning for death. It's also about planning for incapacity. So each spouse gets powers of attorney for both financial and healthcare. So you can pick someone to manage, pay your bills and manage your accounts if you're incapacitated, and can make healthcare decisions for you if you can't. Each spouse also gets a healthcare proxy for that. We do a HIPAA waiver, which gives you your healthcare proxy permission to speak to your doctors on your behalf. And we do a living will, which is also known as an advance directive, which outlines your end of life wishes. If you have minor children, we'll also do a guardian document that lives outside of the will, which is much more detailed. And we'll include an explanation of all of the documents and instructions on how to title your assets in your trust. You get a certified copy of your trust, instructions for your successor trustee if you pass away. And then finally, we'll prepare instructions for your loved ones relating to your burial or cremation. And we give you a binder, of course, with all of your original signed documents, in addition to electronic copies of everything, in case you want to email them to anyone, save them in the cloud, make sure they're in multiple locations. Okay, so you've learned everything you would learn in a personal consultation for the most part, which is not personalized, and you've seen our process and our fees. The next step, if you're ready to engage us for estate planning, is to book your peace of mind planning session. And you can do that by calling our firm or emailing me, and I or one of our paralegals can set up a time for your Zoom planning session. And if you have any questions at all about our process or packages or fees, please feel free to call me or email me anytime. There's my contact info. Okay, now we have time for a few questions, if anyone has any. I see a couple here. Let's see. When would I need an irrevocable trust? Well, I mentioned we can use an irrevocable trust like a Q-tip upon the death of one spouse to protect some assets to make sure they go to the children later on. We can also use irrevocable trusts for tax planning. We can use them to prepare for special needs child, Medicaid asset protection, or even just, if you have a high risk job like a doctor and you're worried about getting sued, we can use an irrevocable trust to provide additional asset protection. And that's something we could talk about in a consultation too, because everybody has their own goals and needs for these trusts as well. Let's see. Can I move my house into my revocable living trust with the mortgage? Yes, yes, you can. You can. There's actually a federal law that protects you from having that due on sale clause accelerated if you move something into a revocable living trust with a mortgage. So your mortgage, they can't make you start a new mortgage with a higher interest rate. I know that's a concern for people right now. If you've got a lower interest rate, you don't want to have to redo your mortgage just to move it into a trust and end up paying a higher interest rate. But your mortgage provider cannot make you do that. You're protected. Okay, let's see. We have one more question. What if we want to make changes? What happens and how do we do that? You would contact me. I've done your originals and we'll assess what it is you want to change. How much it costs would really depend on what you want to change. But I have clients come to me all the time to change the future trustees because just life circumstances have changed, or they want to change how things go to the beneficiaries. Maybe they originally did their trust when their kids were minors, and you don't know how things are going to turn out in the future. And they've had one who has special needs, and so they need to set up a special needs trust now. Or they've decided that they're going to go ahead and let them inherit all the money at an earlier age because, everybody is responsible and they're productive citizens and they feel like they know enough to be able to manage their inheritance. So stuff like that happens all the time. So all you do is you contact me and we figure out what you need and how much it will cost, and we go from there. Well, that is it for the questions. Thank you all so much for being here. And please feel free to call me later or email me if you have any questions at all. I am happy to help. Bye, everyone. Have a great night.